Good morning, this is your Kelso Report for Thursday, August 16th. I'm your host, Clark Kelso. We begin today with a question of what constitutes an assault. The defendant in United States versus Acosta Sierra was convicted at a bench trial of 2 counts of assault on a federal officer in violation of Title 18 U.S.C. Section 111. The facts were as follows. While in a lane designated for vehicles at the United States-Mexico border, the defendant threw a baseball-sized piece of jagged concrete in the direction of a United States Customs and Border Protection officer, who was walking approximately 7 to 8 feet in front of a closed, unmanned primary inspection booth. The rock did not strike the officer, though it came within 2 feet of hitting his head. The officer did not see the defendant throw the rock or observe it travel through the air. In fact, the officer only became aware of the rock when he heard it hit the metal gate behind him and bounce off of the gate into the inspection booth. He did not fear immediate bodily harm at the time he heard the rock hit the gate. Instead, he felt stunned and confused, turned around, and immediately saw the defendant. That's when he began to be in fear. Well, this is a great first-year crim law question or question for the bar. On these facts, can the court find the defendant guilty of an assault? The district court concluded there was an assault because, even though the officer only became aware of the threatened battery after the concrete had passed him by, the loud noise caused him to turn around immediately to see the defendant, which generated a sense of fear. The Ninth Circuit reversed and remanded for a new trial. According to the Ninth Circuit, there are 2 theories of common law assault that could support a conviction. The first is an assault where the victim suffers imminent apprehension of a harmful or offensive contact. This is a tort-like definition. The second is an attempted battery, where the defendant has the willful intention and ability to commit a battery, but where the actual touching is not accomplished. Given the facts, the Ninth Circuit concluded that there was no tort-like assault, because the officer did not know of the threatened contact until after it occurred. But the Ninth Circuit remanded so the district court could consider whether there was sufficient evidence of a willful intention to commit a battery. Next, we have an immigration law decision from the Ninth Circuit. The issue before the court in Aguilar-Tercios versus Holder was whether a conviction under the Military Code of Justice, Article 92, constituted an aggravated felony under the modified categorical approach for purposes of an immigration removability determination. Article 92 makes it a military crime to violate or fail to obey any general order, and the petitioner was convicted under Article 92 for wrongful use of a government computer to obtain access to pornographic internet sites. Now, in order to be an aggravated felony conviction, his conviction must have been for accessing child porn. Well, under the categorical approach, courts examine only the statute of conviction to see if the elements match up with an aggravated felony. Clearly, a violation of Article 92 did not satisfy that approach. Under the modified categorical approach, a court can examine judicially noticeable documents from the prior conviction to determine what facts necessarily supported the Article 92 convictions. But none of those documents revealed whether the sites visited were child porn sites, so a majority of the Ninth Circuit panel held the petitioner's prior conviction was not for an aggravated felony. There was a dissent here, but the dissent went beyond judicially noticeable documents in the record of the prior conviction to examine documents related to a different prior conviction than the one cited by the government to determine that the petitioner had in fact accessed 6 child porn sites. The majority rejected this approach as inconsistent with the limited look-back that is permitted by the modified categorical approach. My guess is the majority has the better of it here under the law as it currently stands. I doubt the Supreme Court or the Ninth Circuit en banc is interested in changing its approach to that modified categorical analysis. Now we turn to a juvenile law case, and we learn here you have to follow the right processes before someone can be declared a ward of the court. In In Re CW, the petitioner was subject to a Section 602 petition on an allegation that the petitioner had committed 5 felony counts of commercial burglary. Although she was eligible for the statutory deferred entry of judgment program, there was no indication in the record that she, her parent or guardian, or her counsel were ever given notice of that fact so they could pursue the program as an alternative to being declared a ward of the court. The applicable statutes and rules of the court require the juvenile court to give such notice and to consider the minor's suitability for deferred entry of judgment before entering a dispositional order. Because these requirements were not followed in this case, the First District vacated the juvenile court's findings and order and remanded for further proceedings. Next, we turn to arbitration. Now, as you know, it's very difficult to overturn an arbitration award. The statutory grounds for judicial review of an arbitration award are very narrow. In Nemechek and Cole v. Horn, the losing party in arbitration sought to vacate the award on grounds the arbitrator failed to disclose necessary information which would cause a reasonable person to doubt the arbitrator's neutrality. The underlying arbitration dispute was an attorney malpractice action. The arbitrator found against the client. After the award, the client hired an investigator who found certain professional connections between the arbitrator and the defendant law firm, such as the arbitrator and the head of the law firm's appellate department were both members of the Los Angeles County Bar's Appellate Executive Committee section. That's got about 200 people in it. The arbitrator and the law firm's expert witness in the arbitration, they had appeared together as panelists on various seminars, and they both were members of the Board of Governors of the Association of Business Trial Lawyers. The arbitrator had been employed as an attorney at the firm of Brown, White, and Newhouse. That firm represents lawyers in malpractice actions. And the defendant's law firm had appeared before the arbitrator when he was a sitting district judge in 2006. Well, as you can readily appreciate, none of these professional relationships involved a commercial relationship, and they all simply suggested the arbitrator was a prominent participant in major specialty bar associations, was a prominent judge. On this record, the Second District easily rejected the petitioner's claim that these connections demonstrated any type of disqualifying bias. Next criminal law issue. In People v. Coleman, the Superior Court had ordered that the defendant be involuntarily medicated in order to restore his competence to stand trial. The defendant appealed, alleging that there was insufficient evidence to support the conclusion that he was substantially likely to be restored to competence as a result of the medication. The First District easily agreed with the Superior Court because the record established a nexus between the antipsychotic medications he was to be given and the specific barriers to competence identified by the government's expert witness. In particular, the expert concluded that the defendant's delusional beliefs that non-existent surveillance video would exonerate him of all criminal charges, that was interfering with his competence to stand trial. Testimony from another doctor indicated that when the defendant was treated previously with antipsychotic medications, he experienced resolution and/or control of many symptoms of his mental illness, and the medication stabilized his symptoms to a degree that his treatment team felt he was competent to stand trial. Well, that evidence was more than enough to support the conclusion there was a substantial likelihood that defendant's competence would be restored with medication. The Court of Appeal affirmed the involuntary medication order. And that's it for today's Kelso Report. Have a great day in the law.